Hello, so today we're going to be looking at legal and equitable interests, and this is a very important distinction that we need to make. Now, first of all, we need to make clear what is meant by the term interest. Now, an interest is synonymous with a right in rem or a proprietary right, and if you don't understand the concept of a proprietary right or a right in rem, then I'd recommend you check out my previous video, which was all about estates and the difference between personal and proprietary rights. Okay. So equitable rights in rem, or equitable interests, are rights that were recognised by the Court of Chancery historically, and legal rights in rem were recognised by the common law court. So historically we had two parallel systems of law. We had the common law and equity was designed to deal with any injustices of the common law court and provide solutions and remedies where the common law wouldn't. Now, although there are two separate systems, the courts have been merged and deal with the common law and equity together. And now wherever there is a conflict between equity and the law, equity will prevail. Legal rights in rem, unlike equitable rights, are much more likely to bind a purchaser of land. Now, the conditions and criteria in establishing a right of rem are more easily satisfied by legal rights in rem or legal interests compared to equitable rights in rem or equitable interests in general terms. This is where the distinction has a practical relevance to us. So the fact that a legal interest is more easily or more capable of satisfying the legal rights to bind compared to an equitable interest is where it is important and why we need to understand the distinction here, because a legal interest is going to be more easily capable of satisfying a legal right in rem. So interest in land. The only interests of land which are capable of being legal are the fee simple, lease, easement, rent charge, mortgage, statutory charge, and right of entry. Now, for the purposes of probably most of you, you're only really going to want to focus on the first few, which is the fee simple, lease, easement, rent charge, and mortgage. All other interests, so the restrictive covenant, the estoppel equity, and beneficial interest under trust, are necessarily equitable. Okay, so if we looked at the beneficial interest under trust as one of these necessarily equitable interests, this should be obviously equitable because a trust is a construct of the Court of Chancery. So if it doesn't fit under Section 1, subsection 1 of the Law of Property Act 1925 as an interest in land, then it is going to be a necessarily equitable interest in land. So an estate or interest which is capable of being legal will only achieve this legal status if it is created with the required formality. Now, this is usually a deed plus a registration of that interest under the registered estate regime, which we will look at later. If the relevant formality requirements for creating that legal interest are not satisfied, that right may take effect in equity. So it will do so, however, if there is a valid actual or discovered contract conferring the interest. So there are certain steps that are necessary to create a legal right, but if it fails to fulfill those specific steps to create a legal right, that right can still exist, still can come into existence through equity if there is a valid, whether it's an actual contract or a sort of discovered contract conferring this interest. So let's say I try and make an easement without a deed, and there is a legal easement. So the formality requirements have not been satisfied in order to do that. So if I want to create a legal easement, I would have to obviously create a deed and have a deed to do so. But if I don't have that deed, then I don't have the legal requirements to create a legal interest. However, it may be found that an equitable easement has been granted instead. In some circumstances, you will enter into a contract saying that you will enter an easement sometime next year, and in doing so, a legally binding agreement is conferred. So we can call that a pre-conferment contract. Now, there is a maxim in equity which states that equity looks as done as ought to be done, and they used this maxim to generate a number of further legal rights. So if I contract with you that I will give you an easement, I ought to give you an easement. I am legally bound to do so. Because I ought to give you an easement, equity looks as done as ought to be done. So From the agreement saying that you will enter into an agreement some point next year, equity already recognises that you ought to have an easement, thus providing an equitable easement, because the parties contracted to the effect that they would eventually get it. But more than this, there is a two-stage process. More often than this, there is a two-stage process to gaining an equitable interest when you fail to make a legal interest, but it will become an equitable interest anyway. So Parker and Tazwell in 1858, the law, in this case, it became clear that the law will sometimes imagine, instead of having a failed contract, what you've actually done is entered into an actual contract. So instead of seeing me trying and failing to give a legal easement, it will actually see you as having a contract to provide a legal easement. So once that can be established, the same chain of reasoning as we had with the pre-conferment contracts can be applied. Therefore, if we have a contract, equity looks as done as ought to be done, but this discovered or fictitious contract will only work if the formality that we do enter into suffices to give you a contract over land. Okay? Now, the Miscellaneous Provisions Act of 1989, Section 2 says that a valid contract for an interest in land must be in writing and signed by both parties. So, for our purposes here, is that if the law is to discover in our failed conferral, there has got to be writing signed by both parties in order for it to do that. Otherwise, it cannot find a contract in the failed conferral. So, if it cannot find a contract, then there is no equitable interest, and therefore fails to give a legal or equitable interest. No right over land would be given at all. So, necessarily equitable interest. In general, equitable interests must be created by signed writing. That's the Law of Property Act 1925, Section 53. So there are formality requirements, therefore, for creating equitable interests as well. And one exception to this is the beneficial interest under trust. An express trust of land must be manifested and proved by signed writing. Imposed contracts resulting implied and constructive trusts need not be created or proved by writing. So no writing is needed at all if it's arising from an operation of law. And these are some things that we will explain in a lot more depth. I understand how sort of confusing all these different ideas that you've probably just been thrown at you can be. So don't worry too much about trying to get to grips with the details too much. This is probably quite a good topic to come back around to at the end of your course once you have looked at these different areas of the law too. So don't panic too much in that respect. Now, this diagram here helps you to categorize rights. Now, on the first level of inquiry is a content-based inquiry, and the second level of inquiry is a formality-based inquiry. So rights affecting an estate in land are the potentially unlimited number of rights that could be created over a land. All these rights can be divided into rights in personam and rights in rem. Okay, so if your right in rem does not satisfy the requirements needed, then it is a right in personam incapable of third-party effect. The rights in rem can also be divided into two further categories, which is what we looked at in this video. So the previous video was about the rights in personam and rights in rem, and this video is about this next level of inquiry, where we're looking at the equitable and legal rights in rem. So rights in rem that are necessarily equitable include like covenants or beneficials under trust, and rights in rem that are capable of being legal. Whether they achieve legal status depends on whether they comply with the formality requirements, include like the mortgage, for example, so, or the freehold estate, etc. So this video is really just about trying to get this distinction very clear between the legal and equitable interests, and the previous video is about the rights in rem and the rights in personam. So I'd recommend you sort of looking at both of these videos every now and again throughout the course, because this is these concepts, these distinctions are very, very crucial to land law. And I would also recommend you look at them again at the end of the course, because by that time you would have looked at all the different interests, the freehold, the leasehold, the easements, the covenants, etc., which will really help bring all those topics together and allow you to really understand all all the basic foundational knowledge you need in land law. Anyway, I hope you enjoyed this video, and I look forward to answering any questions you have. So if you have any questions, just leave them in the box below in the comment section, and I will get straight back to you. Thank you very much.